had the fortune of training alongside him has given me, if I can say so myself, an edge over so many other lawyers that I see. I see so many other seniors also who there in the profession who are not able to do some basic things because they were not taught and trained properly. And that really makes a difference. So I hope whoever is in this room is able to get the most out of it. And while I do understand that a lot of you are counting on the video to be posted online, what you won't get in that video is a chance to interact with sir and ask him your questions yourself. So if there are friends who are waiting that when the video gets uploaded, we can watch it there, do let them know that this is probably their only chance that they'll get to interact with sir. You should definitely look to do. Over to you, sir. We're all waiting to learn something new today from you.
Thank you, Mishika and Daisy, for that introduction. Welcome to all the participants for this competition, and let the best team win. But it is, apart from the competition, it is also the learning process. During the, I mean, it's a kind of a learning by doing session when you are performing, when you are preparing, performing, and participating in the competition, you'll internalize some skills. And mediation is a performance skill. As far as the role of the lawyer is concerned, you see, we see the broader qualification of a lawyer. A lawyer does enjoy a privileged position in society because by her or his legal training, you're able to see things that set you apart from the layperson. You have the emotional intelligence that makes you somewhat immune to display emotions and trauma, just like a surgeon is going to become immune to seeing blood. So you can focus more on logic, rationality, so that you can offer a more balanced and objective view of whatever the issue involved. So it is this ability of a lawyer that you will be able to understand, assimilate, organize information which you have gathered from the client during your client interviewing skills, make distinctions whether on law or on fact, explain why situations are similar or different. So, by being a lawyer, by having the legal training, you have, let me put it this way, a superior opportunity to being a good person. You can do something good by virtue of your training. Now, when we put that in a mediation setting, of course, the lawyer is invaluable for the mediation session. But in my view, the role of the lawyer starts much before the mediation session. And in fact, that's a more crucial role. How to, what to know, how to be able to identify how to proceed in the mediation on behalf of the client, and also how to get the client ready and temper the expectations of the client before getting into mediation. So for that, even before you get into a mediation, it is important for the lawyer to do a kind of a conflict analysis, of course, sitting with the client. In the adversarial system, we talk about doing a case analysis, where we try to analyze the legal elements, good facts, bad facts of a case, put a case theory that drives the process. But in mediation, what we do is do a dispute analysis to see how did this dispute arise? What are the underlying interests of the parties? Now, there are many models in different jurisdictions by which the lawyer can do a dispute analysis. One model, which is commonly known as the ranking model, is asking the lawyer can ask the client to consider and prioritize the interests that are most important to that particular client. So in the matrimonial setting, for instance, it could be the wife may say, for me, custody is more important than the financial amount or the full and final settlement. I don't want the husband to claim custody at all, ever, regardless of change of circumstances. Or the husband, for him, if he is the one who's working, may say, for me, the underlying interest is to get out of this quickly and cheaply without having to pay much. I don't mind her having the custody. For either party, it could be the need of for an apology. It could be the need to be vindicated that I'm not a bad person. Should the parties be young and they want to resettle, it could be having a quick disposition of that particular conflict. So the interests can be several. What is most important to a party, to your client? How would they prioritize their interest? So one, even before you get into mediation, you can sit down with the client and say, prioritize your interest. What do you want? And then step into the shoes of the other side. What, according to you, does the other side want? You yourself will get a kind of a framework. You'll be able to see what what interest of one party can be traded off with the interest of the other party. That will give you some clarity how to proceed in the mediation. So, of course, this is a competition, but in real life, you will be surprised to see the things that can spring out just by doing this very simple exercise of asking a client to pen down, to put down in writing, sequence the interest in the prioritize, which is first most important interest, second most important interest, and so on and so forth, and compare that with the list the client prepares as though the client was speaking for the other side. This is one model. Yet another model is what we call the list model, that is walking the client through the Vartna analysis, the reality check, alternatives to a negotiated agreement. So it could be as simple as getting the parties to say, some parties, particularly those who are tech savvy, who Google everything, they were very well informed about the case on merits. So you can ask them, okay, what according to you is your strongest point? What according to you is your weakest point? What evidence do you have to substantiate your strongest point? Put it in black and white, pen it down. What are the issues on which you don't have evidence? And if a party is particularly well equipped, what is the kind of legal submissions that can go in this case? What do you think the judge is going to accept? Do this exercise also from the point of the other side. What is the other side's best point? What is their weakest point? What evidence they have against you to substantiate their best point? You'll see that once that is done, the expectations of the client gets tempered. A wife may say, well, I know he's earning 2 crore rupees in a year. He's offering 10,000, 20,000 maintenance. Why should I take that much? I'll prove he's earning. But then you get down to ask them, okay, what's the evidence you have? The person may say, I have no evidence. The property is in the name of the family. He takes money in cash. His ITR returns are underestimated. I will not be able to prove it, though I know for a fact. But the minute that person sits down and puts in writing what is the evidence he or she has, they'll realize that if the matter goes to court, what is going to be the likely outcome? So, by this model, what you're doing basically is giving a reality test to the client as to what may happen should the mediation not succeed and the matter goes to court. What is the likely outcome from what happens in court? It also gives you, again, an idea of how to proceed in negotiation. And in mediation, of course, the mediator is bound to say, what are your proposals? How would you like to resolve this? So the party would anyway be more realistic, or have more realistic expectations from that particular session. So all this homework has to be done before you get into mediation. Having done this, the role of the lawyer would be to tell the party, give a roadmap of what is mediation. Of course, the mediator will give the opening statement, explain the process of mediation, the fact you can have private sessions, separate sessions, and joint sessions. You can have the thing is there's a cloak of confidentiality, etc. All that the opening statement will cover, but there's no harm in the party being told or made aware of the mediation process. Also, should there be a settlement, what is the legal status of the settlement agreement? As you're well aware, at least if the Mediation Act comes into force, a conciliated settlement agreement is as good as though it's a decree of a court. In a court-referred mediation, the settlement agreement has the status of a compromise application. The matter will go back to the referring court. Statements will be recorded. It then becomes a decree of the court. So there are varying legal status of a settlement agreement, and your client must know that. But this is also an aspect that should be covered before going into mediation. Now, prior to the commencement of mediation, the lawyer must prepare for negotiations. In a real life situation, which may not be strictly applicable here for this competition, but the lawyer should take a call on whether this is a good time to negotiate. One should always negotiate when the other side's need for settlement is greater. Should, in a real life, the lawyer decides to negotiate, or now in this competition, if you're going to negotiate, assist the parties to negotiate, you must make that shopping list. What are the things, what are the underlying interests, what are the objectives that you want to achieve, what is it that your client can live with, what are the things your client can forego or live without, what are the things your client will agree to should the other side's offer be reasonable, what would be the objectives of the other side. All these things needs to be assessed before getting into mediation. So you as a lawyer have to, in a real life, gather full information about the client's circumstances, priorities, interests, or the client wants to see those priorities and interests satisfied, not how you feel they should be satisfied. It has to be done from the standpoint of the client, and that's where your communication skills come into play to gather full information, identify communication inhibitors, overcome those inhibitors so that you are able to have a free flow of information, so that you're able to then piece together and give alternative perspective to the client that perhaps this could be one way of proceeding in negotiation. So this is what you would need to exercise you need to do before you get into mediation. Of course, you as a lawyer must have your own good negotiation bargaining skills in order to discharge your own responsibility as a effective negotiator. Having said that, mediation, as you all are aware, is party-centered, is based on the principle of self-determination. It is the party who decides, not the lawyer, not the mediator. So the role of a lawyer in mediation is that of a problem solver, not strictly as representing or voicing or taking over what the client has to say, since this is party-centered. And so for that reason, during negotiation and in a competition, at least when I just in the competitions, I do see whether the counsel is giving the floor to the party as opposed to taking over the floor. Ideally speaking, the lawyer should take a back seat during the mediation process, unless there's a need to restore, say, power imbalance or to preempt a deadlock or impasse, or if there's a requirement to give a legal input in direct negotiation between the parties. Those are the circumstances where the counsel should become proactive. Otherwise, let the party speak. The lawyer can't decide for the party. The lawyer can't take over that particular discussion. Also, to keep in mind, in mediation, as distinct from arbitration and litigation, many times a lawyer may be in a position where the lawyer has to speak directly to the other side. In fact, many mediators use this as a favorite technique. Let the lawyer of party A speak to party B, and then let the lawyer of party B speak to party A. The lawyer should grab that opportunity. It just gives a different insight into the particular conflict, because you know how the other side is thinking. But here also, the lawyer has to keep in mind that he or she, at the end of the day, a lawyer guided by Bar Council of India rules, which don't sit very happily with the role of a lawyer in mediation. Under the Bar Council of India rules, you as a lawyer are bound by loyalty, are bound by confidentiality, the client lawyer privilege. You can't disclose a fact or law or anything to the other side, even inadvertently. But once you're doing in a mediation setting, if you're asked to converse with the other side, and within the adversarial system, you're not supposed to speak to the other side. It's professional misconduct. But our ethical rules in this country are so vague as far as mediation are concerned that it doesn't really address a situation where a lawyer is a problem solver, where a lawyer, without compromising the interest of his or own client, is also trying to see how to address the interest of the other side so that there can be a win-win situation. That is not contemplated in the Bar Council of India rules, which basically are more for the adversarial setting. So this is something which is yet a matter of debate, a broader, maybe another session, another day. But just be careful that being a lawyer, still we have more clarity on the ethical standards. You can't really cross the Bar Council of India rules. Of course, you must show empathy to the parties, both parties, your client and to the other client. Whoever's in a litigation, whoever has a conflict, does suffer some kind of, some degree of trauma. So there's no harm in being empathetic to both sides, not only your client, but to other side. It also builds your credibility as a fair person, and as a balanced person. But having said that, again, the lawyer should not be unduly concerned about the fairness of the settlement terms his client is accepting. Because in real life, we have seen that in mediation, where the lawyer feels this client can get a better term, a better set of better outcome, and the lawyer jumps in. If a party is deciding, if the party is rational, fully informed, he or she knows what they're doing, and they are coming to a particular settlement due to maybe some other factor which may not be monetary or which may not really be apparent to the lawyer, they're agreeing to something, maybe to salvage a working relationship, even between husband wife. They say it would be, let me get a social credit by conceding on this point. A lawyer may not be aware of that. So even where the lawyer feels that there can be a better outcome, a better deal for the client, the lawyer should not necessarily get involved. If the client is taking a call in a rational and a coherent state of mind, in no circumstances should the lawyer take over the mediation process or dominate the discussion. So if you do that in the competition, you're going to lose marks straight away. And the reason for that is pretty obvious. If the lawyer is the one who's doing the talking, the possibility of the parties taking ownership of the settlement that may eventually be arrived at goes away. It's not the party's solution. The whole idea of mediation is everything should come out from the mouth of the parties so that the parties feel it was their idea, it is their solution. So they take ownership of the solution. And once they take ownership of the solution, they will not challenge it, they'll honor it. So it's a principle of self-determination, party autonomy, party decides, not the lawyer, not the mediator. So if you as a lawyer bring the adversarial mindset into mediation to fight in an adversarial mindset for the interest of your client in the mediation session, you will lose marks. That's not the mindset by which you have to be present in the mediation process. So I've seen competitions where the lawyers give threats to the other side. We'll see you in court if they didn't settle. Obviously, they're going to lose marks because that will vitiate the environment. You're not the voice of your client in mediation. You're there only to taking a backseat to intervene only in limited circumstances where there's a legal issue or power imbalance or there's a deadlock. The idea is for you is to help in solving the problem, not in saying if the problem is not solved, we know what we have to do. So that approach, the mindset changed that from the adversarial to the non-adversarial. So I think somebody's mic is on. That adversarial mindset, the lawyer has to leave behind that adversarial mindset when he or she comes into mediation. Now, should there be a settlement, there the lawyer can and must be proactive in formulating the terms and drafting the terms of settlement along with the mediator. Many mediators like to draft the settlement agreement themselves, which is a good idea because it preempts certain loaded terms from coming into a settlement agreement. But should the lawyer be asked to assist, or lawyer can offer terms, the language of the settlement agreement has to be non-evaluative, balanced, positive, free from blame assessment, no legal jargon, simple language, preferably the language of the parties. More so if it's a settlement agreement that is going to be capable of enforcement in court. So it must be specific, unambiguous, complete, enforceable, executable. So you do need lawyering skills for that. Who will do what in how much time, what's the responsibility of each person. So that's where the lawyer's role comes in and help the mediator draft the settlement agreement so that there are no loopholes, there's no fine print. There's nothing by which the other side can wriggle out of something he or she's agreed upon. So when it comes to once there's a settlement, which is to be done by the parties, and should the parties then want to summarize the terms and then try to put it reduce in writing, that's perhaps where the lawyer can take over. And of course, if there is no settlement, again, it does not necessarily need to leaving the session in an acrimonious note. The lawyers should congratulate both parties for whatever they've done and hope that in future maybe there'll be a settlement. There has been progress. The parties could not settle at this stage. So this is broadly speaking, in my view, what should be the role of a lawyer in a mediation session. It is, I know, in a competition format, both the parties are assessed, the client and the lawyer. I do not intend saying that the lawyer should not have enough time to speak, so that how do you make the assessment? So it's not a question of the time allocation. It is the content what the lawyer should be focusing on when the lawyer is speaking. The lawyer should be very careful not to say anything, but which takes away from party autonomy. The lawyer should, many times the client would defer to say, let me talk to the lawyer, I'll go by what my lawyer advises me. And then the lawyer should not fall in that by saying, okay, fine, I'll advise you, why don't you do this? Then the lawyer takes over the conversation. They are the lawyer who have the participant will lose marks because that's not the role of the lawyer. What may happen in the chambers, what may happen outside the mediation session where there's the lawyer is advising the client is different from the role of a lawyer in the mediation session. So, keeping your time since it's almost 11, I think if I think I can stop here and then probably tease out more different aspects of this if you have any question answers.
Thank you so much, sir. We will start with the questions. You guys can indicate in the chat box if you have a question or just raise your hand. We'll go one by one. I did have a question, sir, and it is mostly around real mediation. What you said about threats, about not openly giving a threat because it makes things acrimonious. But sometimes, while we are negotiating as lawyers, we know that we have some trump cards that will legally help us, and we do want to use it in negotiation. Now, how I have gone about it is mostly inform the mediator that in a caucus that this is the situation that we have, and this is the reason why we are pushing a certain thing, or we had this a legal thing in our favor. Is there a better way to sort of still
No,
not be threatened, but
I think
let the
that's
other side play?
well. Let me put it this way: if it in a court-next mediation, particularly, I mean, if once the legal issues have already been crystallized, Both sides probably know where they stand. Should there be a situation where one party is not aware of it, again, that is for the mediator to remove the power imbalance again, where the
Hmm.
mediator can take the lawyer of the other side in a private session, of course, followed by the private session of the lawyer of the other side as well, and then gently suggest that the lawyer read a particular branch of law, etc. Where
Yeah.
both lawyers are fully aware of the legal implications, simply by putting it on the table might run down the other side, then make them feel small. So that will
Hmm.
take away from the goodwill of the parties that's sort of be generated. So what you're doing is the right thing, route it through the mediator. Have a private session with the mediator, with or without your client. Tell the mediator that this is the way we see, this is our reality check, this is what we're likely to get from court, but then why should we agree here? And from the if his a person in the matrimonial setting, for instance, if it's if the argument is that he had this kind of income, for the wife, and she's entitled this much, I'll anyway get out from the court, then
Hmm.
why
Hmm.
should we agree to anything less here? And then what about these aspects of the child's education, the higher education, marriage, etc.? They're not being, which but also being fully aware that maintenance is always an interim order, interlocutory in nature. One can always revisit it. So can guardianship and custody. But having said that, you can talk to the mediator. Let the mediator then speak to the other side to say, "Oh, how do you do your reality check?" Because again, the mediator is on a tightrope. Mediator can't do the reality check for the parties.
Hmm.
The mediator has to get the parties to do the reality check themselves. But with the information which has been given in a private session, the mediator can then tell the other side to do a reality check to say that should this mediation not succeed at this stage, matter goes back to court, what is the likely outcome in court? So you have given your message as opposed to giving a threat where you're giving this much, I'll get this much out from the court. Instead of doing it directly, which will put the other sides back up.
Hmm.
It's
Hmm.
better to route it through the mediator. So what you're doing is the right way, I would say.
Thank you, sir. That is helpful. There's a question from Anshika. Anshika, you can unmute yourself and ask.
Good morning, sir.
Good morning. And you also switch on your camera if it's convenient because I just see a blank screen.
Yeah, anyone who's
Um,
asking questions, please switch on your cameras.
Yeah.
okay,
If it's
yes, ma'am.
convenient, of course, if you're in a position to switch them on.
Oh,
Yeah, tell me.
good afternoon, sir.
Good
Good
afternoon.
morning, sir. Sorry. So my question is, as you said, I mean, I didn't get that thing. Can we ask the council, ask the other party, questions for gathering information from them?
Wait, as a counselor, you're saying.
Yes, sir, as a council.
You see, under the adversarial system, you can't even speak to the other side. But in the mediation setting, the mediator will welcome the lawyers, and it's like one big party where everybody's trying to say, how do we resolve this? So many times the mediator tells where the parties are prejudiced and but the counsel are more objective. So a mediator can tell the counsel of one party, send everybody out of the room, call the counsel of party A, and call and call party B itself, and say, why don't you have a conversation? So that why don't you explain your perspective to the counsel? Maybe he or she can then impress upon his own client. So the idea of that is to be able to convey the perspective of a client to the other side's counsel. A similar exercise can be done then. The counsel of the party B will speak to the party A directly, in the presence of the mediator, of course, to understand the perspective of party A. To ensure neutrality, it has to be even handed. So if one counsel has been given the opportunity to speak to the other party, the other one should also be given that opportunity. So, so that will be ensure even-handedness. The idea of this is not to gather information. The idea of this is that the lawyer who's supposed to be distanced from the problem, who's not the one who's been conditioned or prejudiced, whose mind is open enough to understand what the other side is saying also and what is their underlying interest, so that without compromising on the need of his or own client, they can also address the need of the other side. So when this lawyer then goes back and speaks to his client, he can tell his client, yes, the other side is also has this point, has this concern, which seems to be valid. What can we do to address it? We are getting what we want, but for to get the other side to consent to give what we want, they have this concern. How do we address it? So suppose somebody in a private session says, suppose it's the lawyer's husband, the husband has a lawyer who is speaking to the wife. And the wife says, I don't mind giving him access, but he's in extramarital affair. There'll be a divorce. He'll marry her. I don't want the child to be exposed to inappropriate conduct. That's my concern. But she's not voiced it to the husband. So then the lawyer can speak to the husband to say, well, this is a concern. What can we say? How do we address that concern? So it is only to gain a more insight, another perspective into why parties are not settling, why is there deadlock, what is the issue between them. So that technique, now this would not be permissible under the Bar Council of India rules. Which is the reason which I talked about, that our ethical issue, the standards have yet to be laid down. Mediation Act does contemplate laying down certain standards. Mediation is a practice of law, but it is not only a practice of law. Anybody can be a mediator, a child counselor, an architect, an engineer, a doctor. So it's a multidisciplinary approach. Do we need an interdisciplinary code of ethics? You are the lawyer, if you're doubling up as a mediator, cannot advertise. A child counselor who's a mediator can advertise and solicit work. So there's a complete lack of clarity in this regard. So while a lawyer, that's the reason why I say this, the purpose right now is not for the lawyer to gather information directly from the other side. It anyway can't be a discovery process. It is only to understand the perspective of the other side, and then it could still fall within perhaps the very loosely within the regulations of the Bar Council of India for professional conduct. Okay?
Thank you, sir.
Thank you.
There's another question by Soil. Soil, can you unmute yourself and maybe switch on the camera to ask the question?
Yes, ma'am. Good afternoon, sir. Good afternoon, ma'am. I primarily have two questions. How do you decide when to intervene actively and when to step back in the mediation or negotiation session? And secondly, what's your approach to handling parties who are very positional and unwilling to explore any further interests?
No, as far as the first question, I assume it is that when should the lawyer in a mediation step back and intervene? So the general rule is that the mediator should anyway should step back throughout the mediation session. It's a bad idea in mediation competitions. I've seen that where because they are normally teammates, they say, well, this is my lawyer and he or she's also my good friend. You're undercutting the professional nature of your own law counsel. So I've seen that happen in some competitions. So the lawyer has to come strictly in a professional capacity. Should be saying, and if when they've been asked to say something by the judges or in the format, they can say that I will be taking a back seat. I'm here only in case I feel there's necessity for me to intervene, if to give a legal input, or if where if I can help in preempting any kind of a deadlock or any unpleasantness, or if there's a power imbalance. Of course, you do not need to say power imbalance, but that's when the actual reasons when a lawyer should get in are either when there's a power imbalance, that is, there's your own client's mind is clouded, or they're too traumatized, they're not rational, they're saying something against themselves. It could be due to the trauma, it could be due to lack of knowledge. Your client may not have a knowledge about a particular aspect. So there the lawyer can the step in. So power imbalance could be due to many reasons. Could be a wrong understanding of law. In matrimonial setting, it could be I want the marriage expenses, when the wife is entitled only to alimony, maintenance, and istridan, not marriage expenses. So whether it has to be in the guise of alimony or other heads where you can get that money out for marriage expenses. But if she's pitching a case only on marriage expenses, saying, I don't want his alimony, I don't want anything from him, I want what I spent. She may be justified in saying so because she may not want anything from the other side, but whatever she spent. But she's not entitled to that in law. So it could be due to a wrong perspective of law. So one is power imbalance, one way there's legal input between a broader picture between what the both sides stands are. Legally, one side is unsound. Again, that's a different issue whether to do it in a private session, routed through the mediator, etc. But that's where a lawyer can at least have an active role. And the third is, like I said, impasse. And the fourth is when you come to the stage of drafting settlement. Otherwise, a lawyer should simply let the party do the talking. So that is the, in a real setting, that is the way it ought to be. Of course, you need to tailor it depending on your competition rules, how you allocated time, etc. So that's a different point. But when you're introducing yourself in your role, you should have the clarity that this is what my role is. That you're there as a problem solver. And you can even say that I've come here as a problem solver. Obviously, I'll need to keep in mind the interest of my client. But we're more than happy to understand the concerns of the side to see if they can be addressed as well without compromising the interest of my client so that we have a settlement. Okay, now your second question was, if you just repeat, because I thought that was a broader question outside the mediation session, where their positional stand, a party's taken a positional stand, that is where the pre-mediation sessions become useful, where you ask the parties to do what the list model, the Vatna, where you make them get down, okay, this is the position you have taken. Yes, he's earning so much, he has to give me this much. Very well. Okay, fine. You may be entitled in law if you're able to establish that. What evidence do you have? If she says nil, then she still will climb down. So the idea of tempering the expectation or having that particular session prior to mediation is to temper the expectations of your own client. So you need to work on your client before getting into mediation, as opposed to being telling the client, the mediator, well, my client has taken this position and I'm helpless in this matter. So the whole idea of going to mediation is that you need to prep up your client, but not by telling him or her what to do or what not to do, but by taking them through the different process, mediation, negotiation, all these are process. The client has to move away from the stance they've taken to the underlying interest. For that, you do this pre-mediation dispute analysis and then take the party into the mediation. Okay?
Harini, you can go next and then we can have Vishwajit.
Sure, ma'am. So, good morning, sir.
Good morning.
I'm hope you're having a good day. I'm Harini, and I just wanted to first highlight a point. Throughout the course of your explanation, I noted the fact why you are a great lawyer. So, in the world where people don't show compassion to even their own clients, you wanted us to show compassion to the other parties as well. So I think that's what makes you special, kind of person.
Thank you very
So,
much. I always feel a good lawyer is one who can, and in fact, many people say that a good lawyer is one who can, achieve the interest of your own client without having to blame anybody. So one doesn't need to go into litigation. One doesn't need to put the other person down. If you can still protect your client's interest, then you've done your job.
yes, sir, obviously. So the question that I have is about the private caucus session. The first thing is whether the council has the right to call for a private caucus. And the next thing is, can it be called more than once? Like, is only one session allowed, or can we have more than one private caucus session?
Anyone in the room who feels they want to say something to the mediator or the mediator himself or herself can call for a private session. But if you're having a private session with, say, the lawyer on one side, you must have the private session with the lawyer on the other side to show that because that will retain your credibility and your neutrality, the even-handedness, where the process has to be fair. So equal opportunity must be given to both sides. So even if you don't need the private session with the other side's lawyer, call for one. and try to have it fall around the same time. You can have as many private sessions as you want to. The whole in competition, of course, due to lack of time, you're allowed 5 minutes, 10 minutes, I assume, private sessions. But in a real life, you can have private sessions back to back, you can private session, joint session, private session, joint session, keep shifting gears between private and joint. And throughout this private and joint session, you run the different stages of mediation. So there can be private sessions at the time of uh, after your opening statement, joint session, getting the parties to share the perspective, we can go into private session, even to identify the issues. Uh, Keep shifting gear in private and joint session, identifying the issues, identifying what is the real problem, underlying interest of the parties, asking the parties for the options, evaluating each option, uh, communicating each option. All this can be done in private sessions, getting back to joint, back into private, getting back into joint. So the different stages of mediation, at every stage of mediation, you can have private sessions. Many times, parties don't want to see each other itself. After they're so angry because whenever there's a area where emotions run high, and you feel some amount of venting is good because it helps the other side to realize the impact of what their comments have done or the actions have done. So if they didn't mean to do it, they will feel apologetic about it. But too much venting will vitiate the environment. So if you feel in a given case a private session itself is good enough, then you don't even need to go back to a joint session. Just have private sessions and then eventually have a settlement, then come to a joint session. And where you feel one party is apologetic and you want to do restorative justice, where the person who's apologized wants to try to make amends by apologizing, expressing regret, so that along with the settlement, there's also closure to the trauma. There's that healing touch. Everybody has questions of which they want answers. Why has this happened to me? Am I a bad person? So many times you use those practices to get that healing touch. But that will happen only when one party wants to express regret. If a person doesn't want to express regret, you can't do restorative justice. So, depending on the nature of the case, the parties, the circumstances, you can keep switching from private sessions and joint sessions. Okay? Yeah.
Thank you so much, sir.
Yeah.
Vishwajit, can you go next?
Yeah, a very good morning, sir. Good morning, and good morning, everyone. I'm assuming my voice is clear and perfectly
Yes,
audible.
yeah, you're audible.
Yeah,
Yes.
thank you, sir. So my query is like our negotiation problem mentions a lot of domestic violence allegations and mental health issues. So one being a legal counsel, what shall be his approach to address all these issues and without escalating the conflict? So what should be a legal counsel's strategy in order to acknowledge all these claims without actually derailing the spirit of the negotiation?
Well, you see, the thing is that in the approach we have in mediation is that we are not on merits of the case. That's for the court to test with the allegations and
Yes.
counter allegations. That's why we're not getting into the background. Let me assume whatever you have said is correct. What next? How do we finish it now? So we don't revive or discuss those issues because the minute you get into the past as to who's done what, the environment will get vitiated. There'll be allegations, counter allegations. So the way is to sidestep it by saying, I would, as a negotiator, you would say, let me say what party A is saying is absolutely correct. Let me also assume what party B is saying is absolutely correct. What now? So, what is the way forward? What are the proposals on the table? Mediation is all about the future, not the past. So, it is here and now. We're sitting across the table. We can't undo what has happened. Let us assume whatever both sides are saying is absolutely correct. How do we proceed further? Where one party is still traumatized because of what may have in the past, then that's the job of the mediator to go in a private session, let the be some venting, etc. Let the person come to rational state of mind, and that's where the mediator will again exchange neutrality for removing that kind of mental block, or can outsource it to a counselor, etc. But where parties are otherwise rational and they can discuss there's no point getting into the past. You simply preempt them from talking about the past. Somebody starts, you say, very well, we'll go on the proceeding, whatever you're saying is correct. But what now?
So,
Yes.
but let's say if the other counsel brings it up, then what shall be our approach?
Again, the approach would be the same. The mediator would need to actually step in at that point of time, or because the mediator, the environment will get vitiated. Your approach will simply say, "This is not the forum for it." If my friend is of that view, all that we can do in court.
Yes, sir.
That
Again,
all.
it's of criminal nature too.
I'm sorry.
Sir, like all these allegations are of criminal nature too. So,
No, it's
like,
not. See, the Domestic Violence Act itself, I mean, proceedings, though they do it under the Criminal Procedure Code, they are actually quasi-civil. So even if for
okay.
490A, that's a non-compoundable matrimonial offense.
Mhm.
So that's also a criminal offense, but you do have mediation in that. So it's not so much of it being civil or criminal. The issue is merits of the case, the what a person is saying, the truthfulness or accuracy of what a person is saying, or otherwise, is to be tested by evidence before a court. This is not the forum for it. Mediation is not a forum for getting into the merits of a case or whether the person is speaking the truth or not. Mediation has got nothing to do with whether the person is speaking the
Mhm.
truth. Your premise will be, as a mediator and as a negotiator, that both sides are speaking the truth. Now, if that is the position, what next? How do we resolve this? So forget about the past, put proposals on the table.
Mhm. Yes, sir. True, sir.
So the shift, the thrust has to be, how do we proceed? How do we move forward? As opposed to who did what or laying blame assessment. The minute you get into blame assessment, the mediation will fail there and then. I know that's not
Indeed,
the
sir.
format. That's you're asking a question more from the real life point. That's not the format of the competition. Here you've been given your facts, and by force you. That's the reason these competitions, in moot courts, and these I always say, you'll actually have to unlearn all this when you actually become mediators or you become lawyers, because these are all good examples how things are not done in real life. But you're in a competition format, so please go as per your instructions, because you're in a competition format. But in a real life, this is the minute one lawyer is being difficult or one the client is being allegation or after allegation, either the mediator steps in. If the mediator does not step in, then you as a lawyer would say this is not the right forum for all this. Even we can make allegation, counter allegation, but this is not the forum for it. We reserve that for the court. Right now, let's try to find a way forward.
Yes, sir. Surely, sir. Thank you
Okay.
so much for insights, sir.
Yeah. Okay.
Okay, we do have five more questions, but we'll be taking questions only till 11:30. We'll start with Shivani and then Ridhima. I'm putting this order only because your names are proper. Aryashri, Sudiksha, and Sam 29. You will go after them because your names are not in order if there is time. So, Shivani, you can go next.
Good morning, sir.
Morning.
Now, my question is what are the circumstances when a parties or council should go for a break? Like, what are the time periods when exactly a party should ask for a break
A
or
break,
side
you mean to
exchange?
say, wherever a person feels that they want to, you see, mediation being a process, parties are being deconditioned from whatever is the prejudice, whatever led to the conflict cycle. Their mind is blocked, so they're being deconditioned. Wherever a person feels that they need to have introspect, they want to have a second thought about something, they want to consider something, or they're too emotional, or that there's too much anger in the room, environment is negative, you can always ask for a recess or for adjournment, or say, okay, we'll come back after 2 days. The parties can do that, lawyers can do that, the mediator can do that. Okay? Okay.
Ridhima, can we have you next?
Good morning, sir.
Morning.
Sir, my question is that if in a condition it is visible that the other party is not willing to reconciliate or agree on a same pace, then how to cope up with that as a lawyer, as a counsel at that particular
Well,
moment?
that's also the role of a mediator. In the opening statement, the mediator will require both parties to commit to mediation. And mediation means give and take. It's only if you give something, you get something. So that is the role of a mediator, which fortunately may not happen in your competitions because both parties are coming for mediation. But in real life, where a party is coming into mediation only to understand what's the case of the side or as a discovery process, or because the court sent that party, but that party didn't want to come, then that's the job of the mediator to ensure that the parties are committed to mediation. Now, during the course of a mediation, if a party feels that no, I do not want to reconsider my position, it's a voluntary process. It's it's without prejudice talks. A party may have at one point thought, okay, I might go this way, but after keeping the broader picture or keeping in view what is the offer from the other side, I want to stick back to my original position. A party is entitled to do that. So not every mediation is, even if it's a fit case for mediation, not every mediation is ripe for a settlement. There has to be right time for it. So maybe there may not be a settlement at that point, but there may be, the process continues, deconditioning process continues. So maybe there might be settlement sometime after some more litigation fatigue. After another 6 months, they may settle. So as a lawyer, for the other side, you can't do anything to break the mindset of the said party. That's for that party's lawyer or the mediator to work on. Okay?
Thank you, sir.
Yeah.
Ayush, you can go next.
Good morning, sir. Am I audible?
Yes.
Sir, thank you for this informational session. My question is with regard to the format of the competition. Since in the competition, we will have a specific set timeline or the duration in which we have to compile all of that. So, how would you advise? Should we go finalizing small points or a lot of points, or should we stick to a point which will take a lot of time, which will require a thorough discussion as to say between both the parties? It is the central matter.
You see, let me tell you, I think Michigan would be a better place to answer that. But what I've seen in these competitions is that both parties are being asked to share the perspective, and then there's getting setting the agenda, etc. And that's where you talk about the smaller points to the bigger points. And many times, the view seems to be in some competitions that if this is resolved, which is the more fleshy, the bigger point, everything else will follow. So we can have a settlement on the other. Now, in my view, that's a very bad negotiation strategy. Mediation is all about building momentum towards a settlement. So if there are five or six different issues which are put on the agenda by the mediator, always start with the easiest issue. Have that resolved, even if it's a short one. So from that point of view, maybe a shorter one, not the least contentious one. Sort that, the second issue, which is least contentious, then the third issue, so that the mediator can keep saying, well, now issue A settled, issue B settled, issue C settled, only this teeny weeny bit is left. That's the way you build up momentum towards settlement. Parties get invested in that process. Should there be no settlement, whatever they've gained on those three issues, they lose that also. So as a negotiation strategy, it is always easier to start with the least contentious, the easiest issue to be resolved, and then get into the ones which are the most contentious. So just because when you're setting agenda, the parties may have identified interest in a different order, doesn't mean that the discussion has to be in that order. Parties can jointly request, and that's the purpose perhaps of these kind of sessions, where both sides, lawyers, or then the parties can request, okay, let's first wrap up these easier issues where there can be a settlement, but they're in common interest, etc., so that you're then moving on to the bigger ones, as opposed to starting with the most difficult one, spending all your time on that, and then saying there's deadlock on this, so the whole mediation goes out. So I won't really talk about in terms of time, whether small time or less time or more time. I would talk in terms of what is the easier thing to sort out, try finishing that off, so that there's movement during the mediation process.
Thank you, sir.
Okay. Yeah.
Ayush, we'll also be having a mock session soon. We have a mock mediation problem, and we will be having this session soon. So you will be able to see what a proper competition specific session is going to look like. And if you have any further questions, you have the email ID, so you can send us questions on that. Quickly, we'll take questions first from Adishri and then Sudiksha. Adishri, you can unmute yourself and ask the question.
Thank you, ma'am. Good morning, sir. Am I audible?
Yes, you're audible.
First of all, very thank you, sir. It was very insightful. Sir, I have two queries mainly. The first is in the mediation setup, the lawyer is the epitome of the legal knowledge. So, in that setup, to what extent he should show his legal knowledge by citing cases or case laws?
Nothing. A lawyer is not there to show legal knowledge. Actually, lawyer is not there to show legal knowledge, even in court for that matter. But in mediation, we are not on the law. The settlement agreement must be within the law. But the terms a person may waive of their rights, we are not on legal rights and liabilities in the first place. So the example you would have studied when you're doing mediation was the orange, for instance. That if people are fighting over an orange, if A has title, A will get the orange, or B has title, B will get the orange. That's applying the legal principles. But should A say I want the peel and B says I want the fruit, the mediator will say, tell A you keep the peel. So A says I want the peel just to make some fruit, and B says I want the inside of the orange to make juice, for instance. Mediator will say, let A keep the peel and B keep the inside fruit. So we're not on who has title to the orange, we are on why they want that orange. So in mediation, we are not on law, we are not on the legal rights. So the lawyer doesn't need to show any knowledge of law, number one. The lawyer, there's no question of citing judgments, etc. Even the pleadings are not relevant for the mediation process. The job of the mediator and the lawyers is to go from the stance the parties have taken into what is it the parties really want? Why are they fighting? So long it is within the parameters of the law, the mediator and the counsel and the parties can agree to something. Well, A will get this, B will get this. Even if A is entitled to more, so long the underlying interest is satisfied, A will settle for less. So your settlement agreement does not correlate with your legal rights and liabilities. The only caveat is you can't agree to something which is outside the law. Okay? Okay. Is that clear?
Yes, sir.
Yes.
Yes, sir. So my second question is, as we discussed about Batna and Watna, I have this doubt that what are these? Like while reading the mediation problem as well, we have this doubt that what is this Batna and
So
Watna?
basically, I mean, these are words people like to confuse the potential mediators with. Don't worry about them. Basically, it's just comparing a pending offer with what is likely outcome in court. So if we go to court, for example, in a given case, if a person says, this is the evidence I have, I will get X amount from the courts in terms of maintenance. This is what the other side is offering me right now. So you're comparing the two pending offers. The offer which has come from the other side with what is the likely outcome in court. What is your best alternative to a negotiated agreement is Batna. What is your worst alternative to a negotiated agreement is Vatna. And Malatna is your most likely alternative to a negotiated agreement. Basically, you are seeing the alternatives to a settlement in mediation. So when it's only a means of doing a reality test, I want this, I'm getting this this is the offer I'm getting in mediation. Let me compare this with the outcome which I may get in court. And that will make me feel whether should I settle now or should I pursue my remedy in court. So these are terms, so don't get worried about these kind of terms. Basically, these are only different ways of doing a reality test. Okay?
Thank you, sir.
Yeah.
Yes,
Diksha,
thank you,
one last question from you. And if it's competition specific, then Daisy and I will take it. If it's
Uh,
third session specific, then you can go right.
okay, ma'am.
Good morning, sir. Good morning, everybody. Thank you so much for such remarkable points. Uh, as you said that let the party speak. So my question is it the role of the council to just summarize their points or their interests?
No, no. The counsel is that's the role of the mediator. The mediator will keep doing using facilitative skills to to summarize and play it back or reflect it back to the parties to see that the mediator has understood the problem correctly. Where the lawyer perhaps can get in is if the party is saying something but that's capable of misinterpretation, or the other is not that person is not saying something which is complete, and you need to put some caveats, etc. Then perhaps to so that they you get the lawyer can perhaps step in simply to complete it or give the proper interpretation to what the person is saying. If in a real case, in a live case, not likely to happen in a competition. You're going to go prepared, but in a real case, suppose the party is illiterate or a party is not able to doesn't have good communication skills and is not able to give a proper statement, is speaking in monosyllables syllables, or just giving partial information out when the person wants to say something more, then perhaps the lawyer can step in because that again amounts to power imbalance. Then the lawyer steps in there. But otherwise, it's not the job of a lawyer to let his party speak, then summarize what he's speaking. Mediation is a conversation. Even when we say opening statement should not come, opening speech should not come across as a speech. It's not a lecture which is being given. It's a simply introductory statement in few minutes of even make it as short as possible for taking control of the process and asserting authority of the mediator is supposed to be neutral and credible. So the idea is only to kickstart the conversation. And then the conversation shifts from party A, party B, joint session, private session during different stages. So we don't really have that segmented um stages. It should be seamless. So there's no question of one party speaking and then handing the mic to other person to start giving a summary and then coming back. So that's not the way it's supposed to work. If the minute you start seeing it in a segmented form, it defeats the purpose of mediation. Okay.
All right, so
Something,
thank you so
teacher,
much.
that we'll cover in the mock also. The idea is for the flow to be not be identified. And that's how a mediation should look like. That even though your timings are defined and what you have to do is defined, but the way the conversation flows is more flowy and not going from one person to the other, like handing off a mic. So that's something that should also get clarified in the mock drill. Thank you so much, sir. I'm sure students may have more questions, and we'll try to take care of those as much as we can. Thank you for taking the time out on a Sunday.
Yeah.
For the students, we will have this video online, and if you have any more questions, you can send them to us. Thank you, sir.
Thank you. All the best to all the participants.
Thank you so much, sir. If there's
Thank
any
you.
questions from the organizing committee, then Daisy and I can stay for a minute. If any competition specific questions you guys have. Also, from the next session, please start naming yourselves as per the instructions given. Abhinav, Arishri, Avantika, Diksha, Ishna. There's someone called Motorola Edge. Please just follow instructions, guys. It makes our lives easier. Prashansa, Prasi, all of you, just have your team codes and then your names. From the next session, we would like for you to follow that format. Okay, I'm guessing none of you have any more questions, so we will see you probably now we have 3 weekends up to the competition and we're seeing you each weekend. So all the best, and we'll see you next weekend. Thank you.